gosh, we have a lot of questions today, 29 questions. We are going to have to move through these. Okay, the first one is, what is the statute of limitations to retain both paper documents and emails relating to HOA business, either as a board member or as a homeowner? Is there a statute? What is the Arizona statute number? So really there is no statute specifically on like how long we have to keep the records. We have a cheat sheet on this that I would really recommend that you take a peek at. I think it's called Records Retention. You can find it on our website at mulcahylawfirm.com. Next question, are CC&Rs and ARC guidelines prohibit anything visible from neighboring property? Yet the board and ARC keep wavering on approving permanent home lighting and now plan to install it on the owner's clubhouse. These lights are very bright, flashy, and clearly visible. How can this be approved under the visible from neighboring property rule? What are your thoughts on this? Well, I think you're kind of balancing here. Like, we have to have lighting because we don't want to have an area that's not illuminated where people can trip or fall. So it's kind of hard for me to comment on this because I don't really know, like, is it a nuisance, the lights, or is it actually just practical? We need to have lights. It sounds like your board wants to install lighting on the clubhouse. Seems reasonable to me. You may want to go to the board meeting and find out more. Maybe if they're too bright and you're saying they're flashing, maybe there needs to be a discussion. If you live across the street and it's, not a pleasant experience for you to look at them, maybe they can tone it down with a little bit lower wattage. But my advice would be have good communication with your board, talk it through and express to them your concerns and see if you guys can work something out. Okay, next question from a board member, number 3. Does A.R.S. 33-1804 apply to HOA boards and committees? This is in the Planned Communities Act, 33-1804. It's the open meeting law. So yes, it does apply to HOA boards and applies to committees to the extent that they have regularly scheduled committee meetings. Question number 4, must the chair of a board meeting be present at the meeting in person? Can they act as a chair via teleconference or video conference? So short answer on that is yes, they can act as a chair. If they're on video conference or teleconference, that's fine. You don't have to be there in person under the law. Number 5, what do you know about co-ops? Can it be converted to an HOA? So we don't have a lot of co-ops in Arizona. A handful, really, like definitely less than 50. It's a different structure. It's kind of like almost like an apartment type structure where, it's different than an HOA or a condominium. Can it be converted to an HOA or a condo? It would be very difficult to do it. I'm not saying that it can't. It'd be kind of similar to like a apartment to condo conversion, but it's going to be messy and it's going to be expensive to do that. Okay, next question, number 6. Regarding violation letters. Currently, we send out a violation notice with letter 1 and give the homeowners 21 days to correct things. Next letter, per board rules established in 2015, says letter number 2 is a $25 fine. What is the best practice that fits state laws regarding violation letters? Letter number 1, notice. Letter number 2, a reminder. And letter number 3 is the fine. Thank you. Okay, so we have a great cheat sheet on enforcement that I would really encourage you to take a look at. It kind of outlines, what our process typically is for violations. The key thing on violation letters is you got to set up the fine right. So typically we send a violation letter. We send a courtesy one first just to be nice. Hey, you may have forgotten, but, your landscaping in your yard is in serious need of, maintenance. Friendly one. Then the second one, it kind of amps it up a little, like you have a certain number of days to, get your landscaping looking nicer. And then, maybe you threaten a fine there. Under Arizona law, remember, most important thing on fines is you have to set it up right. Got to give them notice of the violation, an opportunity to be heard, which could be send in the letter, send an email, come to our board meeting. And then you levy the fine after the opportunity to be heard. That's the key thing under Arizona law that you really need to dial in on. So notice of the violation, opportunity to be heard, and then you can levy the fine or not levy the fine based upon what feedback you get or whether or not the violation has been corrected. Okay, next question, number 7. When should an HOA resort to levying a special assessment? In my opinion, they should only be used in dire circumstances. such as normal financing or budgeting planning could not be predicted. I mean, it really, there is no hard and fast rule as to when to use a special assessment. You just have to look at the totality of the facts that you have in front of you. Like, you've got a serious problem. It needs to be addressed by your community. We don't have any money in our account. You have to balance the need to have something, fixed versus, the financial side of this. And so, I mean, I'm not saying it should only be in dire circumstances. I'm just saying you got to look at the totality of the circumstances after, talking with your lawyer and your management company, and think about what's best for the community so that the board is adhering to their fiduciary responsibilities. Okay, question number 8, regarding elections. What is the distinction between a power of attorney and a proxy? Does a power of attorney make a person eligible for election to the board? So a couple things. Proxies are no longer allowed in Arizona unless you're under developer control. So that's out. What you do use is a mail-in ballot. Only the owner can vote the mail-in ballot. So it can't be a power of attorney, cannot vote the mail-in ballot for that lot or unit. Also, a power of attorney, although you may be able to sell the property under a power of attorney, you can't serve on the board and you can't vote for the association. So power of attorney doesn't mean really anything in an association context. Owner votes, owner is the person that can be on the board. Okay, next question. Number 9, can you split a capital improvement between operating funds and reserve funds? There is nothing in the CC&Rs regarding this. Okay, great question. Yes, we talked a little bit about this before when I talked about layering. So if you have a capital improvement project, it really should be paid out of the reserve fund, truthfully. Some associations don't have a reserve fund, so they have to pay it out of the capital improvement fund. But association best practices would be you have a capital fund, which should be like your reserve fund, and then you have an operating fund, which is how you pay your month-to-month bills. I guess, can you split it? I'm not sure what you mean by that, but I mean, a lot of times we take money out of the operating fund each month to fund the reserve. So I guess it's kind of, that way. But remember, if you're taking money out of your operating fund, you did your budget based upon your needs to pay your operating expenses. You may have a shortfall and you're paying your bills in the operating side if you're robbing Peter to pay Paul. So be careful on that. Okay, question number 10. What can be done if the association no longer has, or say they don't have, an unedited version of an open board meeting? They don't have it. They don't have it. Not much you can do there. Hopefully they're being truthful, but if they don't have it, I suppose you could, go to the A.R.S. and file a complaint against them and have an administrative law judge say, hey, you were supposed to keep that unedited version for 6 months. But I mean, if it's a pattern, or you think they're being deceitful, maybe that's something you want to do, but probably not much you can do. Look at the minutes. Those would be, a good indicator of what happened at that meeting. Okay, question number 11. Will A.R.S. 33-1255 permit an HOA to make electronic statement delivery the default and then requires to opt in to mailed statements? This is a law that was passed several years ago. I really do not like this law because it does make it a requirement that we have to provide a statement to everybody, regarding what the assessment rate is, whether it's monthly or quarterly. It really is a hassle for many associations and an added expense. So the question is, will it permit an HOA to make electronic statement delivery? Well, really only if the owners opt into that, because under this section, let's see what it says here in my office. It's amazing. They put the statute right in here for me to help me answer this question. Let's see. Honestly, this is kind of one that might be one that you may need to call me at the office or email me this one separately. But I think the way that we read the law previously was that, the association is required to provide it to the owners. And most owners have opted into electronic statement, and that's how most associations are doing it. So they just email it to you just to show how much money is owed by the owner to the association. Okay, question 12. Does making a single payment or any partial payment reset the foreclosure clock, or must it be the full amount? And are boards or management free to negotiate with the homeowners? So it really depends. So under the new law, so this is going to be for planned communities. So if an owner makes a partial payment, let's say that we can't foreclose until it's $10,000 and maybe they owe $11,000 and they make a partial payment. So now they only owe $8,000. It just, we have to look at it on a case by case basis, because if you're a planned community, we have to see, are they 18 months delinquent, or do they owe $10,000? There's a lot of strategy going on with some of these homeowners so that they don't get foreclosed on. We just need to look at, okay, do they still qualify for foreclosure? And if they don't, we can't. If they do, we move forward. Are boards or management free to negotiate with owners? My only caveat on that would be yes. If it's with the attorney, though, let the attorney handle it, because that could be seen as a way to undermine the attorney. And, we don't want that. We want the owner to pay, and you hired us to help you collect the debt. Don't go around us if it's with the attorney. If it's not yet with the attorney, yes, of course, try to negotiate always with the owners to get them to pay, even if it's a payment plan or whatever. Question 13, our community voted and we now retain the right to mandate no overnight street parking. Homeowners say it isn't their vehicle, so we have to pull tags at a cost of $35 per pull to find out who the owner is. If determined the vehicle was indeed theirs, can we charge back the $35 in addition to the fine? I don't think that you can do that. That's just going to be a cost of doing business. Recognize, though, that if you charge them a $50 fine, that kind of covers the $35 cost. Okay, question 14. We had a $6,000 pool motor replaced. Are we required to move cash from the reserve to the operating cash account? We currently have enough funds in the operating cash account. This is probably a good question for your CPA, but the pool motor likely is going to be, and it was a replacement, so it's probably going to be a capital improvement thing. Check your reserve to see if it's listed as part of the reserve. Maybe it's considered an operating expense. If you have enough funds in the operating cash, I think most associations would just pay that out of operating cash funds. Next question, 15. I'm a member of 2 associations where the treasurers appear to use the reserve funds like a piggy bank to cover unbudgeted annual expenses like winter overseeding. What recourse does a homeowner have to curtail this activity? Well, I would write a letter to the board just expressing your concerns, and I'd consider running for the board yourself. I don't know if this is going to rise to the level of removing the board, but you have the right to remove the board if you follow the procedures under Arizona law. I suppose you could go to the ADRE, you could hire a lawyer to write a letter, you could file a lawsuit. These are all different options that you could have. Okay, question 16. Do you have any thoughts on the recent news on Western Alliance Bank, with Alliance Bank specializing in HOA banking? Okay, so my office provided a little background for me. Apparently, there's concern due to risk issues. This is, I'm not saying this is just what we found on the internet. I think the key thing is your bank FDIC insured? That should be your first pivot. Yes. You should not have more money in there than the insurance provides coverage for, right? So, whatever the FDIC limit is, you should not be having more money in there, because then it's under, you don't have insurance for anything that's over the FDIC insurance amount. So yes, of course, you want to keep an eye on that. And you want to have your money be in a bank that is FDIC insured, and you want to be under the limits that the FDIC insured bank is. So that if in the event that the bank folds, I'm not saying that that's going to happen here. I'm not in any way saying that. It's not my opinion. But you'll have the insurance with the federal government for the amount of the deposit. And we've seen this in our industry. I've been around a long time. So 29 years, I've seen a couple banks fold. And as long as you have, the money under the FDIC insurance limits, you'll be fine. And the bank's FDIC insured, of course, you'll be fine. Okay, question 17. We had a special assessment for an insurance policy 2024-25 policy year. The accounting department did not use the funds collected that were sitting in a special account for this purpose to pay the premium. It should have zeroed on July 25th, but has a balance. Now the board plans to just use this for the 25-26 policy year. With months January to July closing short, wouldn't doing so obstruct the actual status of the year closing? If the funds weren't used for the purpose imposed, can the board just reclassify the money? Lots of problems with this question. You really shouldn't be using a special assessment typically to pay your insurance premium, unless your documents would, allow for that. And most documents I've seen probably wouldn't allow for that, would not allow for that. This is a question for your CPA. Run this by the CPA for the association. I don't know. Oftentimes something is put in the budget as a line item. We don't spend it, for that purpose. So I don't know, maybe it can be done, maybe not. Question 18, we are in Mesa and have a group home in our community that gets upwards of 100 plus police calls per year. It's a nuisance with emergency vehicles blocking the street all the time. Do we have any legal recourse to deal with this? So check out our cheat sheet on federal laws. We talk about group homes and how they, are an exemption under the Fair Housing Act, and associations have to allow them. But we don't have to allow bad behavior in a group home. So this clearly falls under that category. What I would recommend is that you contact our firm, and we will contact the owner of that group home and, let them know that, hey, there's going to be fines. There's going to be potentially a lawsuit to stop this nuisance from occurring in our neighborhood, and go legal on this owner right now. And the behavior should stop if we do that. Okay, question number 19. It looks like we have 29 questions total. So 19, special assessment payment plan. Can you charge interest? Is the HOA acting as the lender? So I would not charge interest. I think it's an administrative nightmare, and I'm not sure that you can charge more. For doing this. You could charge a late fee if they're not paying it on time. And I would not, you're not a lender. We're not in the business of lending as HOA, but payment plans are something that's pretty common for special assessments. And you just build the late fee right into it, and just they have to pay the late fee if they don't pay it on time. Question 20, our HOA just passed a retroactive dues assessment of 5% back to the beginning of the year. We became a homeowner in April. Do we have to pay the 5% increase for January to March? It's hard for me to answer this question without knowing more, but, I've never heard of a retroactive dues assessment increase going backwards. Very odd. But of course, you're not going to have to pay it for the time that you were not the owner. Just that whole thing does not sound legally correct. So you may want to reach out to us. I don't think you can go back retroactively. You may have a claim against the person you bought the home from or the condo from, but that whole proposition, I've never even heard of somebody trying to do that. And I don't think that is even legal. So I'd have to hear more about it. Okay, question 21. Our HOA is planning a special assessment vote. After reviewing the CC&Rs, we learned that one major repair item is actually the homeowner's responsibility, not the HOA's. However, since the 1970s, our HOA has maintained this, even though it was the owner's responsibility. Now the boards reversed their position, requiring homeowners to pay for the costly repairs resulting from years of deferred maintenance. Do homeowners have any recourse? Well, if the CC&Rs say it was their responsibility and the board gratuitously may have made repairs for it, I still think the document says that it's a homeowner's responsibility. So likely the homeowners are going to have to, pay for the expense to, repair whatever this issue is. Question 22, thoughts on a structured bridger financing, vehicles versus large special assessments, large scale capital projects in terms of supplemental to adequate reserve funds. Okay, so structured bridger financing, vehicles versus large special assessments. Okay, so I'm assuming you're meaning like a loan, where the bank gives you like a quick loan to help you bridge the gap until you can get the money. Or maybe you're just doing a loan just to pay for it. It's pretty common. It has to be in your CC&Rs for you to do that. Definitely get legal counsel involved to help you navigate that. We don't see associations taking out loans that often, but, I at least have a couple a quarter that we are helping associations navigate. Question 23, our master association consists of 6 separate entities. The master has not held any meetings or taken any action for over 10 years. When the master association eventually holds a meeting, would that meeting be open to all homeowners? Very odd that they're not, conducting meetings. They should be under Arizona law. It should be an open meeting, of course. If it's considered a planned community, they are subject to the open meeting law and they should be having regularly scheduled open board meetings. Question 24, a board now schedules a regular board meeting every other month. Is that action in the best interest of the members? I don't know. Maybe you don't have enough business to have a meeting every month. You may want to ask, hey, why did you go to bi-monthly? Do your documents require a monthly meeting and they're, violating that by going to every other month? I'd be interested to hear what they have to say. I do have some boards that work on a quarterly basis. Some do it every other month. Most do it every month. So I would just open the lines of communication with your board. Okay, question number 25. Does exterior painting of the units qualify as a capital project? It depends. Usually it is a reserved item on the reserve. So, usually it could be considered as a capital improvement project. Okay, next question. 26. Our community is labeled underfunded and not approved by the FHA, Fair Housing Act, with several major capital projects pending. Will banks consider lending to an HOA in this situation for a construction loan to fund repairs and offer homeowner payment plans? Okay, so you got a lot going on in this question. So different things mean different things. So FHA, if you're not approved by FHA, that just means that your owners can't get loans through government, through Fannie Mae or Freddie Mac. And that happens sometimes when the association doesn't have an adequate reserve or when an association has a lot of rentals. That's a separate issue. So that means your homeowners can't get, loans from the federal government to purchase or refinance. That doesn't mean that an association can't get a loan. Typically, an association is going to go to a private bank, not to the government, to get a loan. And in my experience, I don't think I've ever seen a bank say no to giving a loan to an HOA. If we have the right to do it under the documents and we have a way to pay it back, I don't think that that's going to directly impact the association's ability to get a loan. Question number 27. What should happen to the contingency fund if you don't spend some or all of it? Can you put it in the reserve? That's a great question. Okay, here's what you need to do. When you do the special assessment, you say that if there's any money left over at the end of the project, that money will be transferred into the reserve account. So that should just be written right into the vote on the special assessment. I agree to a special assessment of $10,000 per owner. Any money that may be left over, and then say what it's for, obviously in the vote, and then have a sentence in there that says any money that's left over will be transferred into the reserve account. Perfect way to handle it. Next question, what steps are needed so that our community can begin the process of leaving the Master Association? You need a meeting with our firm. Very difficult to leave the Master Association, just so you know. You have to look at the documents. It's probably impossible, but you may want to reach out to your legal counsel to talk about that. Okay, next question, 29. Our HOA transferred funds for a capital improvement project to a new 501c3 nonprofit, but the details and future obligations are unclear. Are there legal precedents for using a third-party nonprofit to handle HOA projects and bypass member involvement? I really don't see this very often. Sometimes, there's a donation from an owner to fund a project, but this is very unusual. So I would say this is not something that I see very often, maybe twice in my 29-year career. So this is definitely something I would be asking some questions on. Okay, question number 30. Let's see how many, we got 3 more questions and then we're done. Okay, many neighborhoods oppose group homes, sometimes out of fear rather than facts. Since group homes are a protected class, where can we find information on protecting their residents and owners? When does state or federal law override CC&Rs, and can boards impose small business restrictions to avoid these protections? So check out our cheat sheet on federal laws, because we give a really good overview of, how group homes are a protected class and how group homes should be allowed, as long as they meet the requirements set up under the Fair Housing Act, and how associations really can't do much, other than, treat them just like any other owner. And if they're making violations, we can treat them like any other owner and, fine them or file a lawsuit against the owner or whatever. Where can we find information on protecting their residents and owners? I'm not sure mean by that? Oh, so I think maybe you're looking at it on the side of the owners of the group homes. Well, I mean, the Fair Housing Act, obviously the Attorney General's office, would be when you first stop if you feel like you're being discriminated against by an association. This is definitely a federal law that overrides the CC&Rs because a group home is a business. And most association documents have a prohibition against business, running a business out of your home if it meets certain requirements. But this is a federal law that trumps our documents. And, check out our cheat sheet on this. It's something that we have to allow. Okay, next question, 31. When is the perfect time to plant the seed to our homeowners that we are planning a special assessment? How many months ahead of time before an owner vote? I would say as soon as possible so people can start planning. What you don't want to do is shock and awe them with we're having a special assessment of $5,000 due next month. That's not going to be good. You probably want to set that up over a 9 to 12 month period so people can start planning. Okay. Question number 32, last question for today. If the community uses their reserve funds for a large project and then the reserve study is under 50% funded and the allowed 10% annual increase in assessments is very unpopular with members, what is the board to do? Deplete reserve funds can limit people's ability to get a mortgage. This is a great question. I don't have the answer for this. I mean, it's healthy. Try to have your reserve study in that 50 to 80% funded range. These are tough decisions. Unfortunately, when you serve on the board, you have to make the tough decisions. How do we pay for it? Do we increase the assessment every year by 10%? Do we do a special assessment? Do we take out a loan? Are we going to deplete our reserve fund, to pay for this and try to build it back up over time? These are all things that you should get advice from your trusted advisors, from your attorney, your reserve specialist, your CPA, your management company, so that we can help you make the best possible decision for your association. Okay, wow, we had a great day today. We got through a lot in an hour and a half. So we had over 219 viewers on Zoom and Facebook Live. So amazing turnout today. Thank you so much for being here today and caring about your community. We have a couple more opportunities in 2025 for you to listen in and get free legal advice. Our next First Friday is Friday, November 7th. That's where you can join us on Zoom or Facebook Live and have one question answered for free. That's going to be from 9 a.m. to 10 a.m. on Friday, November 7th. You can find out information about that on our website. We also are going to be teaching a class for Surprise, City of Surprise. It's going to be called the Surprise HOA Summit. It's going to be on Tuesday, November 12th from 6 o'clock to 8 p.m. It's going to be a hybrid format. It's not limited to only Surprise owners and people who live in Surprise. It can be from anywhere. We're going to be talking about new legislation, what are responsibilities of board members, and how an owner can make positive change in their HOA or condo. So check out our website on that to get more information, find out how to register. And last but not least, we have our November class, which is class number 11 of our Neighborhood Services HOA Virtual Academy. That's going to be November 18th at 11 a.m. And we're doing a boot camp for all of our homeowners, board members, managers, and we're going to go over what are the 10 most important things you need to know about associations, and we're going to give you some tips and secrets. As always, all information regarding our classes, whether they're virtual or in person, are going to be on our website. Spending your lunch hour with me, and look forward to seeing you at future classes. Take care.